All right, so welcome, Tim. How about you tell everyone who you are and what you do?
Sure. My name is Tim Meyer. I am the Richard Allen Cravath Distinguished Professor in International Business Law at Duke University School of Law in North Carolina in the United States. So I'm a trade lawyer and professor. I practiced law at the U.S. State Department for a number of years, and I write and publish extensively on U.S. and international trade law and policy.
Okay, great. Thank you. So when it comes to the eventual ruling from the Supreme Court about this case regarding Trump's tariffs, what should particularly Canadian policymakers, businesses, investors be looking for in that ruling and how it might affect the landscape in Canada?
So I think obviously, the top line ruling, whether or not the Supreme Court allows these tariffs to stand, is the sort of most important issue. Now, obviously, a lot of Canadian products have been shielded from the IEEPA tariffs through the USMCA exception. So the specific affirming or reversal of the lower court's decisions in this case is not necessarily going to immediately affect the tariffs on Canadian products. But the law that's at issue here, IEEPA, is the most permissive, if construed to authorize tariffs, is the most permissive law that the president would have at his disposal to impose tariffs in the future. So President Trump and his administration have throughout their both first term and since retaking office in 2025, January 2025, really been looking for laws that authorize tariffs with relatively minimal judicial review and relatively minimal requirements, particularly in the form of administrative procedures prior to imposing tariffs. So, if the administration wins this case, that's going to suggest that IEEPA may become much more prevalent in the Trump administration's toolkit. So, to the extent that Canada and Canadian businesses may be more focused on, for instance, the Section 232 tariffs. One could imagine that the focus would shift to IEEPA if the Supreme Court were to ultimately uphold the administration's position. Obviously, it's also possible that Canadian businesses would be importing into the United States products that are not covered by the USMCA exception. So in that case, importers might also be attuned to any necessary procedures to go about claiming refunds if the plaintiffs do win before the Supreme Court.
Okay. So building off that, if they do win, in your brief, you sort of wrote about this possibility of refunds. So tell us a little bit more about how might that work. I imagine businesses would be really keen to find out about, whether or not they'd be getting refund on both sides of the border. So how realistic is that? What amount of time would that take? And just walk us through what you think could happen there.
Yeah, so first of all, it's probably useful just to clarify why it is that Canadian businesses could still be seeking refunds, even though Canadian products have largely been exempt from these tariffs. The nationality, if you will, of a product doesn't follow the nationality of the importer, the exporter, or the owner. So it follows. It's determined by what are called rules of origin, which basically have to do with where the sort of enough value was added in the supply chain to the product. So it's entirely possible that Canadian businesses are actually paying IEEPA tariffs on products that they are sending to the United States that are not Canadian origin products. So Canadian businesses could very well be interested in seeking refunds, even though there's been a USMCA exemption for most of the tariffs that are at issue in this litigation. So, in terms of the procedures, what importers are going to want to do is you're going to want to really make sure you've been keeping records of the tariffs that you've paid. The tariff scheme in the United States now is actually quite complicated. There are IEEPA tariffs. There are Section 301 tariffs if you are importing something that's a Chinese product. And then, of course, there's all the Section 232 tariffs. The administration issued what's called a stacking order in April of 2025 that sought to clarify the relationship between some of those. But for importers, it's a pretty significant burden to sort of just keep track of all of the tariffs that might have been paid or potentially owed. So part of it just starts with like you got to keep records. And then there's an administrative process in the United States that importers can use to basically try to correct the record on the tariffs that are owed. So if the plaintiffs win, that will control the legality of these tariffs. And so the sort of most important issue in a refund will have been determined by the Supreme Court. But the importers will then still have to actually go through the administrative process of demonstrating that they have in fact paid tariffs that are now have been deemed unlawful. That's initially done through a procedure that is basically involves filing a correction form with CBP, and you have a little over 300 days from the time you paid the duties to do that. After that, the duties are what are called liquidated. And so then you have 180 days to file a protest with the government. And if you don't get relief through either of those processes, ultimately a lawsuit could be necessary at the Court of International Trade in New York.
Okay, interesting. Yeah, you raised a really good point there about the USMCA compliance and how the exemption is not, 100%. And we've looked a lot up here about just how businesses have been scrambling to complete paperwork that in a prior period was not always necessary because something might have been eligible for USMCA treatment, but they, without proving the rules of origin and everything, then they would um, not bother claiming it because it would get under MFN anyway, or 0% for whatever reason. Now, of course, it's a choice between 0% and 35%, so it's a big deal. But the end of de minimis has further complicated things for Canadian businesses there as well. Um, as you mentioned, there's a lot of tariffs, some stack, some don't. It's a lot to wade through. What has become clear in all this is that tariffs are here. They're an essential part of Trump's trade policy. And that trade policy is very much about reshaping the way, the world as we knew it before and bringing manufacturing back to the US. Prime Minister Mark Carney in Canada had, I think we all thought initially, set out a goal of removing all tariffs from Canada. He's now acknowledged these things are here to stay, and there's been a big focus on the sectoral tariffs in particular because Canada is benefiting largely from that exemption. So even if these tariffs are struck down by the ruling, I think, likely outcome everyone sort of acknowledges is that the Trump administration will try to bring in tariffs in a different way. So what should we be looking out for there? And in particular, what should Canada be looking out for in terms of how it could be affected?
So, one of the things the administration has quite clearly laid the groundwork for is the expansion of the sectoral tariffs, which are being imposed under a different law, Section 232 of the Trade Expansion Act. That was the statute that the Trump administration used and frankly sort of broke glass on during its first term when it imposed the steel and aluminum tariffs and did the autos investigation, which has formed the basis for that investigation was done during the first term, but was not sort of activated, if you will, until this term. One interpretation of the Trump administration's actions is that IEEPA was sort of because it has no administrative requirements before the president can act, that was the use of IEEPA was basically to get them going right away while they backfilled the investigations that are required under Section 232. So Section 232 requires that the Commerce Department complete an investigation within 270 days from initiating an investigation. They don't have to take the full 270 days, but there is going to be some lag under Section 232 that IEEPA doesn't have. I think if you're looking at this from outside the U.S., the continued expansion of 232 tariffs is likely to be a feature of the administration's position. There are also a number of other statutes that have not previously been used to impose duties, but actually do, unlike IEEPA, explicitly authorize the use of tariffs. And so a lot of people thought actually that these statutes, and I'll say what they are in a second, might actually have been what the administration would have used in the February kind of through April timeframe. And I think it's reasonable to think that the Trump administration, if it wants to start imposing these more sweeping tariffs that don't necessarily have an administrative foundation in the form of an investigation, that it's going to look to these other statutes. So what are those statutes? There's a law called Section 122 of the Trade Act of 1974, and a law called Section 338 of the Tariff Act of 1930. Again, neither one of these has ever been used to actually impose duties. And so there's the possibility that there would be legal challenges to their use as well. They have different limitations and different requirements, but neither one of them appears to require the same kind of administrative process that Section 232 or Section 301, which has been the basis for a lot of the first term Trump tariffs on Chinese imports, requires. So you could look to the Trump administration to try out one of those authorities as well if it really wanted to go with something that didn't require an administrative investigation.
Okay, and those, as I understand it, has some time limits and some other sort of parameters around them. And yet, I'm wondering if that's any comfort because as we saw with the Section 232, and yes, it requires an investigation. There are steps to follow that are beyond what we saw with the IEEPA tariffs, and yet it has seemed every time that when an investigation is announced, the conclusion is pretty much a foregone one. And I'm curious about what you make of that and how everyone should sort of be anticipating these things to go.
So it's a really good question. I was involved in a lot of the Section 232 litigation during the first term. And if you read Section 232 and if you read Section 301 as well, the law looks like Congress wrote in some limits. And they wrote in things like time limits in particular. And they wrote in these investigations that are required that one might reasonably think were intended to be reviewed by courts in the same way that courts review the findings of administrative investigations in general. Um, Unfortunately, almost all of that litigation has been resolved in the Trump administration's favor, including a series of decisions that have by the Federal Circuit Court of Appeals in the United States that effectively reads out many of the limits in those statutes. So a couple things that could come out of the IEEPA litigation about that. So one would be that a decision for the plaintiffs might spur businesses to think about whether they want to seek further review of the either 232 or 301 tariffs, and potentially revisit some of those limits, particularly the time limits. So one of the things that the Trump administration has done is it has claimed, particularly under Section 232, almost a limitless authority to modify the tariffs that have been imposed. So to go back to the auto tariffs, the Trump administration completed its auto investigation during its first term. It did not impose any duties on autos or auto parts. The Biden administration didn't impose any duties on autos or auto parts, but the Trump administration picked that finding up when it came back into office this year. To I think most people, that seems like probably there should have had to have been at least a new investigation, just as a matter of sort of common sense and policy. And there is a limit, a time limit in Section 232 that's 90 days plus an additional 15 days for the president to implement from the time he receives the report. So the Federal Circuit, in some earlier cases about the steel and aluminum tariffs, said, look, we don't, we're not going to really enforce that deadline as long as the president sort of announces a general intent to do something. But that case leaves a little bit of wiggle room for the idea that, surely there's some point at which these administrative investigations become stale. So a decision for the plaintiffs in the IEEPA litigation, I think, could definitely spur some litigation over whether or not there should be a reinvigoration or reconsideration of some of those limits in 232 and 301. As you say, there are limits in 338 and 122. So Section 122 has a 15% limit that can only be imposed for 150 days. It's never been used, so it's not totally clear whether or not the president could reimpose tariffs after the 150 days. The best reading of the statute is that the president cannot do that. And in fact, it quite clearly says that the tariffs sunset. But given the way the courts have resolved some of these other limits particularly on the Section 232 cases, I wouldn't be totally confident that the courts, and this is to the point of your question, I wouldn't be totally confident that the courts will see it that way if the president slightly changes the basis for imposing the tariffs. Section 338 is more permissive, so it's a 50% cap. And if you look at what the IEEPA tariffs have been, there's a general 10% tariff, and then there's these reciprocal amounts on particular countries that have generally stayed under that 50% limit. So it does sort of look like these numbers. The president is very fond of 10 and 25 and 50. That he likes round numbers, but there is some thought that those numbers might have been chosen with sections 122 and 338 in mind. Again, we could see litigation about it, but I do think that the business community has become a little bit jaded about the possibility of the courts actually enforcing limits in these statutes. And a big question is whether or not the outcome in the IEEPA litigation is going to change that.
Okay. And just a clarifying question on what you were saying about the Section 232 auto investigation from Trump's first term. That would have been completed prior to the USMCA coming into effect, right? So we're
That's right.
obviously, yeah, the big things had changed there, and that sort of was designed to have that manufacturing be in all three countries, in a sense, rather than the goals, the policy goals now.
That's right.
Okay, is there anything you'd like to add?
Uh, I don't think so. I think that I think those are the big issues. The big issues are, if you found yourself paying IEEPA tariffs, you want to be on top of those timelines with respect to seeking a refund if the plaintiffs ultimately prevail in this litigation. I think companies would be well advised to continue to monitor, as well as the Canadian government and provincial governments, of course, to continue to monitor the situation because there are going to be more tariffs. The tariff landscape is going to continue to be uncertain. I think the larger question from a legal point of view is if the plaintiffs win, is that going to invigorate challenges to some of these other statutory regimes where there really wasn't very much success in the lower courts during the first Trump administration, but there was no Supreme Court review of any of those decisions. So it's possible that businesses may feel, like the door has been opened to challenging some of these other duties if the plaintiffs prevail here. And ultimately, whether or not businesses take that cue from a Supreme Court decision is going to depend on what the actual content, not just the bottom line ruling, but what the content of the decision is.
Okay, thank you.